Hi, my name is Tan Junye. So, standard of care is the degree of caution that a reasonable person would have exercised under the certain circumstances. Failing to meet the standard is negligence, but the person who failed to meet the standard is liable for damage caused by such negligence. If a reasonable person would have done certain action in the circumstances, then failing to do so will be considered as negligence. Alternatively, if a reasonable person would not have done a certain action in a circumstances, then by doing so will be amount to a negligence. So, how about the medical negligence? Here is the definition. The act or omission by a medical professional that deviates from the medical standard of care. Subsequently, simply because a medical professional has made a mistake, that does not mean a medical negligence has occurred. In order to amount to medical negligence, the medical treatment has to fall below the medical standard of care. The typical definition of medical standard of care is the type and level of an ordinary, prudent medical professional would have provided under the same circumstances. On the other hand, the critical question is that would a similarly skilled medical profession provide the same treatment under the same circumstances? If the answer is no, then the medical negligence case has occurred.
Mr. Bolam was a patient at mental health hospital managed by the Friern Hospital Management Committee and had agreed to have electroconvulsive therapy as part of his treatment. Mr. Bolam undergo the therapy without any muscle relaxation and his body was not restrained in any way. During the procedure, Mr. Bolam convulsed violently and injured himself. Mr. Bolam subsequently made a medical negligence compensation claims against the Friern Hospital Management Committee, arguing that they were negligent in their treatment for failing to administer the muscle relaxant, not restraining him, and not providing the full warnings about the risks involved with electroconvulsive therapy.
As a result, Mr. Bolam's compensation claim failed because the accepted practice at that time was not to provide any muscle relaxant, and the doctor thought that providing any muscle relaxant and restraining him would result in an increase of risk of the injury. Also, the accepted practice at that time was not to tell patients about the risk of electroconvulsive therapy unless they asked. Hence, it was found that the medical team treating the Mr. Bolam was act in an acceptable manner and follow the accepted practice. The court held that the doctor has not breached the duty of care, hence the defendant was not liable. The court also held that the medical professional did not breach their duty of care if they have acted in accordance with the practice accepted by responsible body of medical opinion. Due to the complex nature of modern medicine, it is possible that the doctor would behave differently in a given circumstances. Hence, the Bolam test not only concerned about whether the doctor would have provided the same treatment that the other doctor would have done. The key aspect of the Bolam test is that the other medical professionals think that they have acted in an acceptable and reasonable manner to the patient.
Hi guys, I am Tristan. Before stating the development of Bolam Test in the UK, I would like to state a brief introduction on the medical legislation in the UK. Firstly, the UK has an act of the Access to Medical Treatment Act, and this act protects the doctor as they are given the chance to make any kinds of innovations without considering the risk of negligence. The doctors are bound to make their own decisions and they are not bound to be charged of any kind of negligence within the standard care of treatment. In this case, the Act follows the MIB, which is the Medical Innovative Act. This Act, in turn, innovates the doctor and actually creates chaos among doctors, patients, or even lawyers because they think that this Act would in turn cause a remove of the patient's rights. On the other hand, from the journal article of the Best Elbow Forum Practice, Montgomery Practice Direction and Patient's Ruling, it is stated that the disclosure of risk is very important and it is diverted into three parts. The first one is option, discretion, and binding. Three of these risks are exceptionally important for the patient's right to be bound in the medical field. In the case of Montgomery, the previous case departed from the decision made in the Supreme Court. This gives rise to extension in the Bolam Test as the Montgomery rule applies, and this gives a certainty in the medical legislation. All in all, it is important that the UK legislation maintains a certainty and creates stability in the medical field. With reference to the Bolam Test, there's another case of Montgomery and Lanarkshire Health Board. This is a case whereby a pregnant woman who has some sort of like a stunted growth and diabetes is under the standard of care of doctors in Lanarkshire Health Board. She has a 9 to 10% risk of having shoulder dystocia when delivering her baby. Shoulder dystocia is a condition whereby the baby would be having difficulties to deliver from the woman's body. The doctors are aware of the risk, however, they did not inform the appellant about the risk. This is because the doctors assume that this would only be a slight problem during the delivering process. When the woman delivered her baby, despite the 9 to 10% risk of shoulder dystocia, however, unfortunately, the baby was delivered with severe disabilities. And of course, the woman brought this case up to court and held damages from Lanarkshire Health Board due to the medical negligence of the doctors, which they did not advise her on the risk. At first, the courts look at the Bolam Test, which refers to the duty of standard of care of the doctor towards the appellant. Yes, there is. And the doctor advice should be in reference to another medical body which is recognized. A doctor could not simply clarify their own opinion as an opinion which is recognized in court. Therefore, the court convicted damages held from Lanarkshire Health Board is liable towards the woman. In this case, Bolam Test has a stricter application in court, but the courts tend to not follow it. This is because it gives a greater extension to the Bolam Test, which refines into a Montgomery test, which is convicted in the court. This, however, gives distinction of the Montgomery test and the Bolam Test. The Bolam Test is a test where the doctors have to always comply to the opinions from another recognized medical body, whereas the Montgomery rule states that they have to comply to giving advices on the risk of a patient. All in all, in the UK position, the Bolam Test has greater extent into Montgomery rule, which gives a greater picture of the entire medical negligence legislation.
Hi everyone, it's Cindy here. Today, I'm going to shed some light on two cases that Bolam Test did not apply. The first case that I'm going to share with you guys is Polito against City and Hackney Health Authority. This case is about a child who was suffering from breathing abnormalities, was being brought to the hospital, and the doctor who was summoned to actually deal with this matter did not receive the summon because the low battery of her bleep, and hence the child died, and the mother sued for the negligence, arguing that her child should be seen and also intubated. So, the tort of negligence is established in this case, including establishing the breach of duty of care from the defendants to the claimant. According to the case of Bolam against Friern Hospital, it established that a professionals will not be in the breach of their duty if they have acted in accordance with the practice accepted as proper by a responsible body of medical professionals with relevant expertise. And in this case, the claimants must also prove that because of the breach, the harm may have not arisen. The doctor testified that they will not have intubated the child even if they have attended, and this was accepted as proper by an expert who has witnessed the whole case. And therefore, there is actually two things for the court to actually identify in this case. The first thing is whether Bolam Test is applicable, and the second is whether if there is any causation applied. So, the court held that the defendant is not liable to the claimant. The High Court held that it is actually not possible for the defendant to prove that the breach will cause the harm, because but for the breach, some other breach might have been committed. And therefore, it is actually very necessary for the court to assess whether If they have attended and did not intubate the child, will there be any causation arise? And therefore, the court also clarified Bolam Test to actually include a proviso that practice accepted as proper by a responsible of professionals must be made based on a logical and defensible ground. In this case, did not intubate the child is not illogical and therefore there is no breach. The following case that I'm going to present today is Webster against Friern Hospital NHS Foundation Trust. In this case, Montgomery decision is applied. So, it stated that a patient choice is paramount and it has the right to choose the treatment that he wished to undergo. And the role as a medical professionals is by giving them medical information, whereas it is the patient decision that he made based on a wide range of other factors. So, this case was brought up by Heather Butler after his son Sebastian suffered from severe disabilities following his birth in Friern Hospital. The High Court heard how Sebastian's mother, Miss Butler, wanted to have her son induced. However, the consultant advised her not to do so and wanted her labor to be a natural delivery. And hence, the High Court applied the Bolam Test here, stating that it is actually reasonable and responsible for the body of expert opinion would have acted the same way as the consultant had done and not altered the case management plan. And this case has also been reviewed again in the Court of Appeal. It states that several ultrasound scanning has been carried out and the result has shown that the size of a fetus is actually smallest in its gestational age. In this instance, the mother wants her child to be induced immediately without any further delay. So, the Montgomery decision has been again reaffirmed in these circumstances, stating that the mother wished to have her child induced should have been followed. And this underlines that the role as a doctor is as a medical advisor instead of a decision maker. In this case, it is clear that a wide range of factors has actually taken into consideration, and the doctors are now required to have a deeper and better understanding of a patient concerns. So, to summarize the cases that I've been brought up today, it is actually a great milestone for the court to actually apply decisions other than Bolam Test in medical negligence field.
Hi everyone, my name is Tan Yung Hao, and I'm now going to talk about the Bolam test in the Malaysian position. In the case of Chin Kiao and the government of Malaysia, the plaintiff was given a penicillin injection and she died an hour later. It was argued that the doctor did not act on the information where the medical card did mention that she was allergic to penicillin. In this case, the Bolam case was applied. And this case was brought to the High Court. The High Court held that the doctor was liable. However, in a federal court, it was held that the doctor was not liable because there was a lack of evidence in claiming negligence. It was eventually brought up to the Privy Council, and the Privy Council overturned the decision made by the federal court and agreed with the decision in High Court because it is stated that in the medical card, the patient was actually allergic to penicillin. In the next case of Shelia Anak Lelaki, Manicum and Kerajaan Malaysia, it illustrated a special relationship between the doctor and also the patient. And in this case, the issue arise was what is the standard of care by the doctor to the patient. In this case, the Bolam standard of care was applied, and the court held that in maintaining an action in negligence, there are three criteria to be fulfilled. The first thing is that the duty of care owed by the doctor to the patient, and the plaintiff must establish the breach of duty, and also need to prove that the breach of duty that caused a harm to the plaintiff. So, practically, the Bolam test means that while law imposes a duty of care, the standard of care by a doctor to a patient is left for the medical fraternity. In other words, the medical practitioner will have the final say on whether the negligence will occur, but not the court. Furthermore, there are cases that actually departed from the Bolam's test. One of these cases is Kamalan, Anak Perempuan Raman, and Eastern Plantation Agency. In this case, it was actually departed from the Bolam's test. According to Justice Richard Talala, this case followed an Australian case of Roger Whittaker, which means rather than a body of medical opinions, it is for the court to decide after considering all factors that is involved in the case. Also, there's another significant case of Fu Fiona and Dr. Sun Fuk Man. It was also departed from the Bolam's test. In this case, the plaintiff met an accident and she was sent to get treatment. After 2 surgeries, her spinal cord was destroyed and causing her to become paralyzed. It was held by the court that Bolam test cannot be applied in determining the standard of care in medical negligence cases in Malaysia because Bolam test has no relevance in providing advices. This is why the case of Roger and Whittaker was referred to. And also, it was very, very important for the medical practitioner to actually give information to the patient on the risk that might involve in the proposed treatment. On this basis, the Roger and Whittaker case would be a more viable test than the Bolam test.
Hi everyone, my name is Clifford. According to the case of Fu Fiona as mentioned earlier, it was held that the case of Rogers and Whittaker, which is an Australian case, was adopted. Marie Whittaker, who had been almost completely blind in her right eye for many years, consulted an ophthalmic surgeon who advised her that an operation on the eye would not only improve its appearance, but would probably restore significant sight to it. Whittaker agreed to the surgery. Unfortunately, after the operation, there was no improvement to the right eye and she developed sympathetic ophthalmia in her left eye, which is recognized risk of 1 in 14,000, which caused her to lose all sight in the left eye. She sued Rogers for damages for negligence. However, there was no allegation of negligence in the performance of the surgery itself. What was in question was the failure of the surgery to inform her of the danger of sympathetic ophthalmia in her other eye. The court found that the surgeon to be negligent in failing to inform her of the said risk, despite the incessant inquiries of the patient on any side effects of the surgery over her good eye. In Rogers and Whittaker, the Australian case reconsidered the application of the Bolam principle under Australian law and held that except in the cases of an emergency or where disclosure would prove damaging to the patient, a medical practitioner has a duty to warn the patient of a material risk inherent in the proposed treatment. The High Court further held that a medical practitioner has a duty to disclose what the court called duty to warn a patient of any material risk inherent in the proposed treatment. There are some doubts as to whether the decisions in Rogers and Whittaker rejected the Bolam's principle, and the subsequent decision of the Australian High Court in Naxxis and Western General Hospital has confirmed that the Bolam principle does not apply in Australia. Moving on, the cases that adopted Fu Fiona, such as Dominic and Dr. Gun Siu Fong, the deceased was found and taken to the Kuala Lumpur General Hospital, and less than 3 hours after arriving at the casualty department, he died. The appearance commenced proceedings against the respondents in the High Court, claiming the respondents negligently caused his death. 2 questions were presented for decisions of the High Court. First, whether either or both respondents were negligent, and second, even if either or both were negligent, whether their negligence caused his death. The trial judge found for the respondents on both questions and dismissed the appellant's claim. The appellant appealed to the Court of Appeal, and the court held that the plaintiff relied on the recent decision of the Federal Court in Fu Fiona. In that case, the Federal Court held that the standard of care that a medical practitioner should exercise is now a question which is for the ultimate consideration of the courts, and no longer one for the medical professional alone to decide through a responsible body of medical opinion. In the case of Dominic, the Rogers and Whittaker test was applied in relation to the claim of a misdiagnosis and wrongful treatment. On the principle of stare decisis, the court applied the full Fiona test and rejected the Bolam test. Moving on, the second case, Dr. Ismail Abdullah and Paul Hui Lin. The plaintiff brought a claim against the first and second defendants for medical negligence in inter alia, failing to advise the deceased of the risk of acute pancreatitis and acute respiratory distress syndrome after an operation by the first defendant on the deceased to remove kidney stones. The first defendant stated inter alia that the deceased had been advised on and consented to the operation. The session courts did not hold the defendants liable for negligence when treating the deceased, but held that they were liable for failing to advise the deceased of the risk. In allowing the appeal with cause, the judge held that the appellants were not liable as only material risks of injury need to be disclosed, not minimal risks. The Rogers and Whittaker test was applied by the judge to reverse the decision of the session courts. The Bolam test was not applied, and the judge further held that the decision of the federal court in full Fiona represents the law on this subject as applied today. Some very important principles as established in Rogers and Whittaker followed in full Fiona were only material risk of injury arising out of treatment or surgery needed to be disclosed to a patient. Second, the materiality or non-materiality of a risk often requires expert evidence. And lastly, the therapeutic privilege allowed a surgeon to withhold disclosure of a material risk in the best interest of a patient. The issue arising from full Fiona case was that the Bolam test has no relevance to the duty and standard of care of a medical practitioner in providing advice to a patient on the inherent and material risk of the proposed treatments. That said, it would mean that the decision in full Fiona is only limited to the giving of an advice on material and inherent risks in proposed treatments, and that the Bolam test still applies in relation to diagnosis, treatment and management of a patient. Under the full Fiona test, patients must be informed of material risks prior to a procedure much as under the Rogers and Whittaker test. Under the Rogers and Whittaker test, the court will decide upon evaluating the evidence adduced, that is, the court will have the final say, whereas under the Bolam test, the court will defer to the opinion of the medical profession. Besides that, Dr. Kusik stated that full Fiona has brought the issue of the application of the Bolam test to a very critical point for Malaysia. Following full Fiona, Malaysia medical jurisprudence is at an important crossroad. By adopting the Rogers and Whittaker test, the federal court has moved from the Bolam principle in relation to advice to be given to a patient. What is unclear and therefore uncertain is whether the courts will in the future apply the Rogers and Whittaker test to diagnosis and treatment as well, or whether Malaysia will extend the Rogers and Whittaker test to diagnosis and treatments. In a nutshell, the current test adopted by Malaysia courts is full Fiona has not been revisited or reconsidered in any federal court decisions on medical negligence post-December 2006. On top of that, Bolam principle has not been rejected by the Singapore courts, as the Bolam principle was revealed in the case of Dr. Koo James and Muniadi. So, Bolam principle is still applicable in Malaysia, but there are some limitations, but where the limitations has occurred, the full Fiona case would be applicable.
Hi! In a nutshell, what extent is the Bolam test still relevant in determining the standard of care of doctor in a medical negligence case in both UK and Malaysia position today? Now, I would like to invite my group mates to explain more about it.
In the UK, Bolam test is still applicable, but with reference to the Montgomery test, it actually gives a bigger and clearer picture on the medical negligence, which the doctor are obliged to state the risk of each medical opinions.
In Malaysia, on the other hand, the Bolam test is still applicable, and on top of that, the full Fiona case was also introduced. With these two cases on hand, it creates a better approach to the claims of the medical negligence in Malaysia.
Alright, that's all for the video. I hope you enjoyed the video and please feel free to comment below. Thank you so much for watching it.